A takeover involves a change in a company's control. It will happen when the existing shareholder of a big company transfers sufficient share to an offerer in order to give them control over through the voting rights regarding the target company's share capital. When the offerer receives 100% or more of the voting share of the target company, it will be effect the takeover and the takeover is complete. Nevertheless, depending on the shareholder structure of the target company, effective control can potentially be achieved at a lower shareholding threshold. For information, the target company takeover typically occur in the one of the following ways, which is the first way is make a general offer to all of the target company shareholder, and the second way is through private treaty or on-market share purchases or combination of both of it. The target company is usually in the form of cash, but the consideration may also comprise share or debentures in the offerer company or a mixture of cash, share and debentures. Takeovers, mergers and acquisition in Malaysia, which is called takeover, are primarily governed by the Capital Markets and Services Act 2007, the new Malaysian Code on Takeovers and Mergers 2016, and the rules on the Takeover, Mergers and Compulsory Acquisition 2016. First, in Capital Market and Services Act 2007, we known as CMSA. The CMSA regulates and provides for matters that related to the activities of markets and intermediaries in the Malaysian capital markets. The CMSA empowers the Security Commission Malaysia, which is SC, to make recommendation to the Minister of Finance. It also provides for compulsory acquisition by offerers in a takeover and rights of minority shareholders under such a scenario. Second is Malaysian Code on Takeovers and Mergers 2016 and the Rules on Takeovers, Mergers and Compulsory Acquisition 2016. The code is issued and administered by the Securities Commission and is enacted pursuant to Section 217 of the CMSA. It also has recently undergone a significant revamp, and the Malaysian Code on Takeovers and Mergers 2010 has been revoked by the new code. To make a facilitate market activities in a fast-changing environment and ensuring appropriate shareholder protection, the SC had on 15 August 2016 launched the Rules on Takeover, Mergers and Compulsory Acquisition 2016. The code rules stipulate operational and conduct requirements for code takeovers, and it issued as a guideline pursuant to Section 377 of the CMSA.
Role of Security Commission. As of March 1993, the Security Commission is in charge of regulating takeover in Malaysia under Securities Commission Malaysian Act 1993 under Section 50, Subsection 1, Paragraph D. In the discharge of its function, the Security Commission is responsible for administering the codes and is empowered by the CSA to issue rulings relevant to takeover. The CSA also empowered the Security Commission to initiate action against persons who do not comply with the code and its ruling under Section 33A, Subsection 4 and 33D. Objective of the code do not try to prohibit takeover from happening. The shareholder of the target company have the exclusive authorities to decide whether or not to accept a bid. In order to ensure the takeover take place in a market that is effective, competitive and informed, the Code and Securities Commission ruling were created. Application of the code under Section 50, Subsection 1, Paragraph D of Security Commission Act state that the Security Commission to regulate the takeover and merge of companies. Amendment of Section 216, Subsection 1, Paragraph B of Capital Market Services Act 2007 define takeover offer is an offer made to acquire all or part of voting share or voting right or any class or classes of voting share or voting right in a company and includes a takeover or merge transaction. However, effect which has the effect or potential effects or obtain or consolidated control in the company. A takeover offer by parent company for a voting share or voting right in its subsidiaries and an arrangement or organization that involve the voting share or voting right of listed company. Under Section 270 of CMSA, empower the Security Commission to make recommendation to the Minister of Finance and to administer the code according to the objective under the CMSA. The CMSA also provide for compulsory acquisition by offerer in takeover and rights of minority shareholder under such as scenario. Next, under Section 216 Subsection 1 of CMSA, define and acquire as either a person or two or more person acting in concert with another who acquire or purpose to acquire control in a company, whether the acquisition is effected by the person or by an agent or two. Under Section 260 Subsection 2 of CMSA, the term acting in concert is defined widely in Section 260 Subsection 2 of CMSA to encompass person who pursuant to an agreement, arrangement, or understanding cooperate through the acquisition by any of them of voting share in a company, or to act for the purpose to obtain or exercise control over the company. As a general rule, the code only applies to the takeover of public companies, whether or not these are listed, although the SC may by issuing a practice note extend the code's application to private companies. Exemption. The Security Commission is empowered pursuant to Section 290 of the CMSA to grant exemption and waivers upon the application of the relevant parties. For the provision of this division, the courts and any ruling made under Section 270 Subsection 4. In considering whether an exemption should be granted, the Security Commission shall have regards to the general principle under the code.
Next, I will continue on the procedures of legal takeovers in Malaysia. The first process is the offerer must present the offer to the offerings board. Then the offerings board is entitled to make any inquiries of the offer. Next, the offerer is required to announce the offer publicly, including a written notice. After that, the announcement of the receipt should be made by the offerings board. The next process is the submission of offer document by the offerer. The offerings board then required to dispatch the environment to all the offering shareholders. Meanwhile, the offerer needs to dispatch the offer document to the offerings board. Next is the issuance of a board circular by the offerings board, which contains any comments, opinion, and information, followed by the issuance of an independent advice circular by the independent advisor. Next, the offerer shall keep the offer open for acceptance for at least 14 days, then close the offer. After that, the offerer must make an announcement about the result of the offer. The last procedure is to settle the consideration by the offerer.
Assalamualaikum warahmatullahi wabarakatuh. I'm Nurin Batrisha and I will continue with type of code takeover. The first type is voluntary takeovers, which is an offer made by a bidder who may or may not hold shares in a company to purchase all or part of the shares from all current shareholders of the company. Rule 612 of the code: acceptance of the offer shall be conditional upon the bidder having received acceptances which would result in the bidder holding in aggregate more than 50% of the voting shares or voting rights in the offeree. Securities Commission may allow a voluntary offer to be conditional upon a higher level of acceptances subject to the offerer having satisfied the Securities Commission that he is acting in good faith in imposing such high level of acceptance. An offerer may include any conditions where the fulfillment of which depends on the subjective interpretation or judgment of the offerer, or whether or not a particular event happens, being an event that is within the control of the offerer. Second type is partial offers, where a bidder offers to acquire less than 100% of any class of the voting shares or voting rights of a company. Can only be made with the prior written consent of the Securities Commission. The consent will only be granted where a partial offer would not result in the bidder and person acting in concert, PACs, holding more than 33% voting shares or voting rights of the target. The third type is mandatory offers, where a bidder is compelled to make by law. It triggers the obligation to extend a mandatory offer to acquire all the shares of the target which he or person acting in concert with him do not already own if the bidder together with PACs within acquires more than 33% of a company. triggers the creeping threshold or acquires between 20% and 30% of the target's voting shares, and the Securities Commission exercises its discretion to trigger the mandatory general offer requirements. Next is compulsory acquisitions. In Section 280 number 3 of the Capital Markets and Services Act 2007, an acquirer who has obtained control shall not acquire any additional voting shares or voting rights in the offeree except in accordance with the provisions of the code and ruling made pursuant to the CMCA. The last type of code takeovers is person acting in concert, PACs, where voluntary offer becomes a mandatory offer if the PACs with an offerer acquire voting shares or voting rights that may trigger an obligation on the part of the offerer and the PACs to make a mandatory offer. According to the CMCA, PACs shall be construed as reference to persons who, pursuant to an agreement, arrangement or understanding, cooperate to acquire jointly or severally voting shares of a company for the purpose of obtaining control of that company, or act jointly or severally for the purpose of exercising control over a company.
Next, I will explain about prohibited conduct under the Code. Section 35 of the law specifies some measures that the offering company's board may not undertake without the prior consent of the general meeting when it receives a takeover offer, has reason to think that such an offer is forthcoming or is in the process of accepting the offer. These prohibitions are intended to prevent the board from unfairly refusing the offer and include which are the issuance of any previously authorized but unissued share, the issuance or grant of option on unissued share, entering into contracts that are not in the usual course of business, and the sale, disposition or acquisition of a major asset or an agreement to do so. To avoid a takeover, an offering firm's board of directors may also utilize the following defensive tactics. Among these tactics are deeming the bid insufficient and criticizing the bidder. Directors of offering companies should make certain that their critique does not include any deceptive statements. Section 38 of the Code reflects this in part. Firstly is releasing favorable information, which is this may breach Section 16 of the Code, where it constitutes a profit forecast or revaluation of assets without undertaking the proper procedure. The releasing of such information may have adverse results later for offering company director, where shareholders' expectations are raised and this ultimately prove to be unfounded. Second are bonus issue and higher dividends. The threat of a takeover has often caused companies to declare higher dividends as a means of increasing shareholders' loyalty. While this may not be for the long-term benefit for the company, it is a management decision that shareholders may take into account in their judgment of the directors. It is generally inappropriate for the court of the SC to interfere with such decision. And the third is friendly takeover, in which the director of the offering company may actively foster the option in the face of hostile bids, or the first offer may attract rival bidders which the director perceives as more attractive. This may benefit shareholders, especially where they receive a higher price from the white knight. A Foreign Investment Committee guideline, which is in Part 3, Rules 9.5/A of the Code, which emphasize the significance of the Foreign Investment Committee or FIC recommendations, which state where an offer comes within the guideline for the regulation of acquisition of assets, mergers and takeovers. It should be a condition of the offer that it should lapse in the event of the FIC not giving its approval.
so that if an offer falls within the guideline for the regulation of asset acquisition, mergers and takeovers, there should be a condition of the offer that it lapses if the FIC does not approve it.
Case law for this topic is from the case of Panel versus King in 2018. The panel on takeovers and mergers petitioned the Court of Session for an order under Section 955 of the Companies Act 2006, ordaining David Cunningham King to make a mandatory offer at £20 per share for all the issued ordinary share capital in Rangers International Football Club, PLC not already controlled by him and 3 other individuals. The petition and answers called before the Lord Ordinary. At advising on 22nd December 2017, the Lord Ordinary made the order sought and the respondent reclaimed. Section 943 number 1 of the Companies Act 2006 requires the panel on takeovers and mergers to make rules giving effect to certain provisions of directive of the European Parliament and of the Council on Takeover Bids, as well as in Section 955 number 1. The panel on takeovers and mergers was also responsible for the Rule 9.1b of the City Code on Takeovers and Mergers, stating coming together to act in concert, and Rule 9.5 stating the consideration to be offered. The panel applied to the Court of Session for an order under Section 955 of the 2006 Act ordaining Mr. K to announce an offer in accordance with the Code within 30 days of the court's order. And that's all from our group. Thank you.